everyone, it's Professor Green with Federal Government. I wanted to say hello. I hope you all are doing well. Normally in class, before we start a chapter, I would, ask some questions about your prior knowledge to see what knowledge you had regarding the subject. So today's subject is civil liberties, protecting your individual rights. So one thing that you need to know is that people mistakenly use the terms civil liberties and civil rights interchangeably. So generally when you're talking to friends, it's not a big deal, but there is something that distinguishes them, many things that distinguish them. So I want you to go out into the world being able to properly converse with someone regarding what a civil liberty is as opposed to a civil right. So we'll take up civil rights in Chapter 5, but now we'll start with civil liberties. Your civil liberties are your first 10 amendments to the Constitution. So that's a little bit problematic in that we've already said that the Bill of Rights were tacked on so the federal government wouldn't have too much power. So when our nation was founded, initially everyone believed those Bill of Rights to extend only to the federal government. It wasn't until later that they started extending some of the Bill of Rights protections to the states. So we'll see how that plays out. You'll see a lot of cases, and there's so many legal cases. I can't possibly show you, all of the ones that I even want you to see, but some very, very interesting cases. There could be times when someone has a GPS placed on their car, and the question becomes, who placed that GPS on that car? And what does that mean for the individual in the car? I know that debt collectors will do this sometimes if they repossess a car, and then the car will get taken while they're at work or while they're just out. So make sure you pay your car bills timely, or they will definitely repossess your car. Another thing is sometimes the police will put a tracking device on your car, and you saw that if you read the chapter within the first few pages. So, and that was held to be illegal. So I worked near an FBI agent at one time, and he said that he wanted as many cases as he could involving GPS devices because he could successfully defend the people who had their cars taken away on a variety of issues. So I don't know whether or not that worked out for him, but one can dream. He was a retired FBI agent, but okay. So we're looking at Chapter 4, Civil Liberties, protecting individual rights. Now, why is it important that we protect these rights? Because we know that people have violated rights throughout history. So one of the things that's important is that you know what right you have. So if you're ever questioned about something, you know that you have rights in advance, even if you're not able to remember them. Hopefully something from this class might trigger something in your memory. So try to stay enthusiastic throughout this chapter and appreciate some of the things that you're hearing. Some of these people went to a lot of trouble to get these civil right protections documented, changed on the books by filing Supreme Court cases. And more power to them, because that gives me rights, that gives you rights, and others rights that we want to continue to have protected. So we want to start the chapter off by looking at the definitions, and I'm just going to tell you which ones to group. I'm not going to go through each individual definition. So you have civil liberties, number 1. Number 2, Bill of Rights. Number 3, the Due Process Clause. Number 4, selective incorporation. Now, I would group 1 and 2 together because they're essentially the same. Or they have a connection. Let's just say that. They're not essentially the same, but they have a connection. Now, 3 and 4, I would group those as well. They also have a connection. Freedom of expression. Number 5. Number 6, clear and present danger test. Number 7, the imminent lawless action test. Number 8, symbolic speech. Number 9, prior restraint. Number 10, libel. And number 11, slander. I would group everything from freedom of expression down to slander. So that's 7 definitions that deal with speech alone. So you can tell speech is going to be an interesting topic. Next, the Establishment Clause. Go ahead and group that with those others because it's part of the First Amendment. The Establishment Clause is one of 2 clauses dealing with religion in the First Amendment, the Free Exercise Clause being the other. So you have two, and in fact we see free exercise coming up. So on number 14, free exercise makes an appearance. But the lemon test comes in between. So we learned that it also deals with religion. So I, in fact, would group these 3 together. Instead of putting it with the speech, you could, even though you need to know that it relates to the First Amendment, I would group them together because they deal primarily with religion. The right of privacy, number 15. Number 16 is procedural due process. Number 17, the exclusionary rule. So emphasis on that word exclude. What to exclude something means to not allow it. So, or to not allow that person in your group, etc. There are all kinds of scenarios where you could exclude something. The good faith exception, the inevitable discovery exception, and the plain view exception. So I would group 16 through 20 together because they all are connected. So 1 is procedural due process, which is afforded you through several amendments in the Bill of Rights. And then the exclusionary rule. We're going to learn where that comes about. And if you're going to exclude something, you're going to disallow it. And what does that mean for civil liberties? We'll see in a moment. The good faith exception. Again, some of the words will help you out as far as remembering what they're dealing with. The inevitable discovery exception. Again, police are involved with this one, and the plain view exception is definitely something that the police are involved in. So I'll tell you guys a quick story because I always tell it to my students, and while it's a little bit embarrassing, it also goes to show that you need to be careful with who you hang out with. So in college, I had just about graduated, and my boyfriend and I broke up when he learned that I was going to law school. He didn't want me to go to law school, especially out of state. So I had dated him for 4 years exclusively, and I was in love, and the poor guy breaks my heart. Poor guy, yeah. So I decided to go out with someone else, and so one of the people that asked me out was this really nice looking kid that was on bowling scholarship. And so he shows up and picks me up, and I look in the back seat of his car, and there are blocks of marijuana, and I'm taking like larger blocks. And so he said, "Oh, those belong to a buddy of mine." Well, at a certain point, when you have marijuana, it becomes a felony offense. And even though it's in his car and I'm in his car, I can be held accountable. So at that point, I just asked him to take me home, which he did, and was nice enough to take me home. But he did continue calling, which I was so glad when I went out of state. I didn't have to listen to him anymore. But I didn't really think that going to law school and having an offense for having multiple blocks of marijuana in your car would be a good idea. I think they would have probably not let me in if I had that on my record. So there's some interesting characters out there, and don't always judge a book by its cover. So that's your lesson for today, kids. But I have lots of stories like that. Anyway, we didn't get into the whole civil rights issue because he was nice enough to bring me home. All right, let's look at our learning objectives for Chapter 4. 4.1, you need to demonstrate knowledge of the Bill of Rights. Hopefully, you've got some already down. First Amendment, Second Amendment, Fifth Amendment. Those are some of the more recognized ones, but I want you to get them all down and then hopefully be able to, talk about them in conversation with others. So, learning objective 4.2, identify the types of speech protected by the First Amendment. 4.3, describe freedom of assembly and a freedom of association. So that's dealing with freedom of speech, freedom of expression. Freedom of expression just basically covers all of those. So you'll see that term in a minute. So when you're talking about freedom of petition, freedom of speech, freedom of press, freedom of association, freedom of religion, freedom of expression. That's how it's summed up. So there's a test question about that, so I did want to give you a heads up as to freedom of expression. Okay, number 4.4. Examine the principles underlying freedom of press. So press is considered our fourth branch of government, believe it or not. They sort of serve as a checks and balance on our government, even though you wouldn't think that they do. But there have been instances when they've called the government out, and we'll go over a few of those. Learning objective 4.5 is to distinguish between the establishment and free exercise clauses. That's fairly simple, but right now it may seem, difficult in that, what are you talking about, Professor Green? These words seem so big right now. I didn't even have a proper graduation. Please stop. No. With regard to the establishment clause and free exercise clause, one's talking about the government cannot make or establish a religion, and then the free exercise clause, there's some more to that, but the free exercise clause allows you to worship or not worship as you choose, and so that's the difference. But you need to know that the terms that are associated with those rights. Learning objective 4.6 summarized the right to bear arms. Hopefully you've got that down by now, but there's still protests going on. And as far as these protests, when these protests started breaking out and then the military was brought in, I understand that a lot of people went and purchased guns. So gun ownership may in fact have gone up just here recently. I'm not for certain, but I do know that Americans do value this. And during the Obama administration, they thought he was going to take their guns. These people who thought that they have this right to own a gun, and they very much do, but I never saw that he was going to place any sort of legislation restricting their gun access or access to a gun. But I guess the threat is always potentially there, and they want it to be known that they do not want that right to be threatened. So the only issue I have with the Second Amendment is assault rifles and mass killings in schools. So I think there should be some sort of legislation passed as to assault rifles, but I would like for it to be a bipartisan effort rather than one just presenting the evidence. I want them to work together in order to protect our students. Okay. Learning objective 4.7, identify the legal standard for the right to privacy. So, the right to privacy is interesting. It's something that you tell your brothers and sisters. Please respect my right to privacy and get out of my room. Had many a conversation with my sister to that effect. Some that ended very poorly. And my father had to become involved. Okay, so learning objective 4.8 is to apply the knowledge of criminal due process rights provided by the Bill of Rights. We'll get more into that toward the latter part of the chapter, but I want you to know that came about as a result of a more liberal Supreme Court. So some of these protections originated after a Republican, Dwight Eisenhower, also a general in World War II, very famous guy, appointed 2 Supreme Court justices that may have been more liberal than some Americans would have liked. So you have very liberal court rulings during that time. Right. So we're looking at learning objective 4.1, demonstrate knowledge of the Bill of Rights. So the first definition is important, civil liberties. So it's not civil rights. Civil rights deals with the 14th Amendment. Civil liberties deals with the first 10 amendments. So that's some of the variation there. And then civil rights is talking about the government and what they're required to do to provide equality for people and groups. And then civil liberties are talking about your protections, your individual protections from the government. And we'll talk about how we got to the place that we got as far as government and which government they're talking about. So the Bill of Rights, again, those 10 amendments that those pesky anti-federalists had, those federalists add to the Constitution. Okay, so we're going to look at the bottom slides eventually. This is talking about total incorporation versus selective incorporation. So we'll get back to that slide. It becomes important when we do our first concept look. So this next slide will show you it'll show you all 10 amendments. So if you aren't knowledgeable about what they are already, this will take you through it. So I'm not going to go through these individually, but they are there for you if you need it. Speech, guns, quartering soldiers, right to privacy, due process, protection from unreasonable searches, Fifth Amendment, right to those persons accused of crime / self-incrimination. 6, right to a jury trial in a criminal proceeding, and then also right to an attorney and a speedy trial. 7th, right to a trial by in a civil case where damages are more than $20. So you get a trial by jury of your peers. And that has often come up. Who are your peers and how do they get selected? So we'll go about mentioning some of those issues. Then the 8th Amendment, no cruel and unusual punishment, no excessive bail. I won't even get into that just yet, but eventually we will talk about that. The 9th Amendment's kind of a catch-all. It says there may be some rights out there that aren't. And then finally the 10th of the Reserved Powers Clause, States' Rights Clause. And that's in case the federal government becomes too powerful and the states have to point out, listen up, this is our ballpark, you need to kindly step off, back up. So I included this slide because it includes all of the Bill of Rights and when they came in. And also I cited to its source, so if you wanted to purchase this is a poster that you could have that would help you remember the dates of all of the amendments, when they came in, what they dealt with. But I'm hoping you just start understanding what these rights are and keeping them in mind so that you can converse about them and potentially have great conversations and change the world. Like in Jane. All right, the 14th Amendment, the Equal Protection Clause. So what we're going to learn about the 14th Amendment, which was one of the 3 Reconstruction Amendments that resulted after the Civil War. So the 13th, I believe, that ended slavery came about in 1865, and then your Citizenship Amendment, or the 14th, also dealt with due process, came about in 1868, and then the 15th, or the African American male right to vote, came about in 1870. So you have those three Reconstruction amendments that resulted soon after the Civil War. But that 14th Amendment becomes a very powerful amendment, and we'll see why throughout this chapter. And there's one word in this 14th Amendment that makes it powerful. And I'm just going to show you, let's see if I can find it just right off the bat. There we go. State. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So that's one of the clauses within it, but it specifically speaks to the state governments, because what eventually happened after Reconstruction, as you probably know, is that the states didn't really respect those new amendments, and they went about denying rights to African Americans, regardless of what these amendments and protections said. So Jim Crow laws were put into effect. So the things like that had to be addressed. So eventually, the Supreme Court had to address matters and say, hello, states, pay attention. Look, so this amendment becomes important. All right. So this goes through it, but I'm going to show you the four clauses. The Due Process Clause is at the very bottom in this green section. The Equal Protection Clause, the Equal Protection Clause is in this green section. The Due Process Clause is in the red section. Without due process of law, no person can be deprived, no state can deprive any person of life, liberty, or property, natural rights, inalienable rights, without due process of law. So let's see, the Incorporation Clause. So are citizens of the United States and of the state wherein they reside, and no state shall make or enforce a law. So that's the Incorporation Clause. It makes the first 10 amendments to the Constitution binding on the states. It even speaks to states. And then lastly, the Citizenship Clause, which appears at the beginning of the amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, if you remember and think back during the Obama administration, you will know that his citizenship was questioned by conservatives repeatedly. He did end up serving for 2 terms, and there was never anything that that they could provide that suggested that he wasn't, he didn't meet the qualifications for becoming president. Otherwise, he would have been out. I guarantee that had they found something, they would have had a trial, especially during his second term, because they had flipped the Senate at that point. All right, that's just a follow-up to the Bill of Rights. Now, I will say, I put this in here because it's known as the Enforcement Clause. So the Incorporation Clause is simply regarded as the Enforcement Clause for the states. No state shall make, will make, or apply any law that denies to its citizens equal protection of the law. Treat everyone equally, states, and then you'll be okay. Anytime you're not going to treat people equally, there's going to be a problem, or the potential for a problem. Perhaps you'll get away with it every so often. But if people start holding you accountable, and the masses start holding you accountable when they see infringements, then you're going to see uprisings and protests like you see today.
Introductory Concepts in American Government. What is selective incorporation? The Bill of Rights represents protections from federal government actions and includes fundamental protection of speech, religion, press, and gun ownership. Originally, it was understood that these protections only applied to the federal government and not state governments. States, they reasoned, had their own protection of rights and should not fear because they were more geographically proximate to citizens. With the ratification of the 14th Amendment in 1868, the protections found in the Bill of Rights were extended to the sphere of state actions. Total incorporation would be the act of instantaneously applying the totality of the Constitution and its protections of liberty to the actions of state governments. In the aftermath of the Civil War, wholly applying the protections found in the Bill of Rights would have threatened the tentative Union. Instead of immediately incorporating all protections found in the Constitution, the process of applying protections granted by amendments to the Constitution to the states has been a gradual one through case-by-case decisions. The gradual application of the Bill of Rights at the state level is called selective incorporation. Let's take a look. Early interpretation. In Barron v. Baltimore in 1833, the Supreme Court ruled that the constitutional protections did not extend to the actions of state governments. Had the framers of these amendments intended them to be limitations on the power of state governments, they would have expressed that intention. Chief Justice Marshall. In the aftermath of the Civil War, Congress saw fit to pass 3 constitutional amendments to ensure that the rights of newly freed slaves would be protected even at the state level. In 1865, the 13th Amendment abolished slavery. In 1868, the 14th Amendment redefined and extended protections of rights and liberties. In 1870, the 15th Amendment secured the right to vote regardless of race, color, or previous enslavement. The language of the 14th Amendment directly applied the same due process of law required at the national level to the actions of the states as well. Selective incorporation begins. In Gitlow v. New York in 1925, the Supreme Court ruled that the Due Process Clause of the 14th Amendment did indeed require the state of New York to afford its citizens the free speech protection found in the First Amendment. The first wave of incorporation spanned from 1925 to 1940 and focused on First Amendment protections. The second wave of incorporation peaked during the 1960s under Chief Justice Earl Warren and focused on criminal due process protections. In 2010, the Supreme Court ruled in the case of McDonald v. Chicago that the Due Process Clause of the 14th Amendment did extend the right to keep and bear arms for self-defense found in the Second Amendment. The Third Amendment, the Fifth Amendment, grand jury, the Seventh Amendment, and the Eighth Amendment, excessive fines and bails, are amendments and rights that have not been incorporated or applied to the states yet. Summary. What is selective incorporation? Selective incorporation is the gradual process by which the protections of individual liberty found in the Bill of Rights have been applied to the actions of states in addition to the federal government. The process of extending constitutional protections of individual liberty to the actions of states has occurred gradually, through a case-by-case basis, extending to as recently as 2010.
Okay, so now I'd like for you to watch this concept clip regarding selective incorporation. It's very well done. In fact, I've included some of the screenshots already in the PowerPoint presentation, but I include a few more just because some of them are really our own, but I went ahead and completed them for you. So let's look at the questions and the answers. In which 2 decades did the first wave of selective incorporation occur? And that was during the 20s and the 30s. If you remember, Charles Schenck was one of those cases, and we'll look at that case in greater depth, because there are some other concepts that you need to grasp as far as that case is concerned. All right, number 2, which Supreme Court case an example of recent incorporation? That's going to be McDonald versus Chicago, and we'll talk a little bit more about that, dealing with the Second Amendment. Number 3, what is the result of total incorporation? And that would have meant that they would have applied the totality of the Constitution to all of the states at once. And because they valued the Union, and it was shortly, after the Civil War, that they did not feel that telling the entire Union, especially the southern states, that they had to abide by all of these extra protections. They didn't think that it was a timely thing to do. So in order to ease tensions, they let that go, and they compromised a bit, as we saw throughout history. We have compromised on certain issues, and later we will have to address those issues as a result. Now, let's look at number 4, selective incorporation cases of the 60s focused on which area? And that's going to be criminal due process. Those are the exciting cases. Number 5, which of the following amendments was specifically designed to be binding on the states? And that's the one that we've already referenced, has the word state in it, is the 14th. And so that, if you remember, is how the Bill of Rights were selectively incorporated to the states. And they said they didn't want to do it all at once. They were just going to do it gradually, one by one by one. And eventually you'll see that many of the Bill of Rights were included. But it hasn't been across the board. There's some that aren't incorporated. All right, moving on. So this is just talking about total incorporation. This is a link that you can click on if you want to learn more about the incorporation of Bill of Rights to the states. And it's a 3-minute video. So that's just additional information if you would like it. And so this talks about the gradual or selective incorporation. And these are some more selective incorporation clips that I got from Quimby. It's something that I utilized. Well, I utilized after law school just to keep me up on my cases, because I like knowing what Supreme Court cases. I like being able to reference them and saying, whoa, 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 whoa. That was already established in the Supreme Court. Once you have a Supreme Court ruling, you have precedent. And so that precedent applies not to one state, but to all states. So every day things are changing. So you want to stay up on your protections. You want to stay up on, the rulings of the Supreme Court and how they affect you. Okay, so these 3 individuals are important individuals in that they are involved in the criminal due process, selective incorporation process. So this is Miss Delray Mapp. This is Clarence Earl Gideon in Gideon versus Wainwright. And this is Ernesto Miranda in Miranda versus Arizona. That may sound familiar to you, especially if your parent may be a police officer. They have what is known the Miranda rights that they read, or they probably know them by now. They don't have to pull out their card, but they're provided with a card to read to each individual before they're interrogated. So we'll get into that situation, but that's the 3 individuals that were involved in those cases, and I always like to have a face with a name. All right, 4.2, types of speech protected by the First Amendment. Okay, so for some reason my slides are off, so I have to adjust them along the way. Please forgive me, I'm not sure what I'm doing here and why they keep changing in size, but I will figure it out. So now I want to look at Table 4-1, the Bill of Rights. These are some of the selective First Amendment protections. And one of my students remembers it as RAPS, R-A-P-P-S. So it was religion, assembly, petition, press, and speech. So those are the 5 protections under the First Amendment. So this is telling you that you can say almost anything that you want except that which is obscene. And even sometimes some people get away with it. 2, slanders another person. And again, people will get away with it unless they're challenged. Or 3, has a high probability of inciting others to take imminent lawless action. Now that's an important phrase toward the end. You may want to put that in quotation marks or highlight it, something, because imminent lawless action becomes later very important in Brandenburg versus Ohio in 1969. All right, moving on. The press is something that you want to consider next as a protection under the First Amendment. So you are free to write or publish almost anything except that which is obscene. Libels another person. Libels is writing. Slanders is spoken. So know the difference between those two. There's a little bit of other differences which we'll look at in an upcoming slide. And you also can't endanger military action or national security. A good example of this would be Geraldo Rivera back in, I want to say, the 90s, maybe early 2000s, when he started broadcasting on live television while squatted down in the sand, troops' locations, and what they were about to do to different in different situations regarding classified information. At that point, he was asked to leave, and because he was potentially causing an issue for our troops and their protection. So you have to be very careful when you're on television, especially live, giving away information about your troops' whereabouts and their plans. All right, moving on. Assembly. All right, with regard to assembly, you're free to assemble, although the government may regulate time and place for reasons of public convenience and safety, provided that such regulations are applied even-handedly to all groups. So we've had a recent example of this, the time, place, manner restrictions after Minneapolis with the George Floyd killing. You had protesters, you had a lot of destruction, rioting, looting, buildings being set on fire. I sat and watched and watched and watched for days, and I couldn't believe some of the things that I was seeing. It's like you had people that were going into buildings looking for gas lines to explode. It's like felony level behavior. So be cautious while protesting. You don't want, especially, to be filmed on camera committing some sort of felony. So even in filming that action, you should exercise a great deal of caution even in filming the action, just because in doing so you could potentially be charged with the commission of a felony. And several people noted that and said, I'm getting away from this situation because I don't want to be charged. Okay, so what resulted from those petitions was that you had localities, municipalities imposing curfews as a result. So they had to be in by 7 o'clock, or they might be fined, cited for whatever statute or city statute, ordinance that they were breaking. So some people stayed out anyway, but you definitely had people, state governments, trying to protect others and the property within the state from destruction. Next, religion. You are protected from having the religions of someone imposed on you, and you are protected to your right or your freedom to believe in what you like. So that's about as even as it gets. You don't have to practice religion or listen to somebody's religion being imposed on you, and then you can worship however you like. So that's one of the great things about America, is this freedom of religion. So, or the freedom not to practice religion. Now I'm going to pause right there so I can get the next slide lined up. I think it's out of order. Okay, I made a quick adjustment. Now we're into learning objective 4.3, describing the freedom of assembly and association. All right, so earlier I told you freedom of expression encompasses everything. So that is a good thing to remember. That is a test question almost always. So what is the most basic of fundamental rights? It's not freedom of speech. It's not freedom of religion. They include everything in together. All of the RAPPS, the acronym that you've hopefully already started remembering, into the coined phrase of freedom of expression. So that's considered the most basic of democratic rights. But they also want to point out that, like all rights, it's not unlimited. So there are limits as to what you can do as far as exercising your freedom of, as far as practicing your freedom of exercising whatever it is that you're exercising: speech, press, religion, assembly, petition. Says initially the status of the right of free expression was uncertain with the Sedition Act of 1798. So 1798 was roughly 7 years after the Bill of Rights were ratified and added to the Constitution. What had happened with that situation, and you may have read about it in your book, and if you did, I'm proud of you, but you had leaders that were punishing the press for releasing articles that were negative about them. So that's really not aiding or assisting in the protection of freedom of press, freedom of assembly, freedom of expression. So we kind of got off to the wrong start as far as protections go with that freedom of expression. Today, freedom of expression is vigorously protected by the courts. That's actually a test question that I remember. So vigorously protected by the courts. And again, it can't be denied if it endangers national security, is damaging of others' reputations, or deprives someone of their rights. Okay, so we're about to get into some of the important cases as far as tests that the court has established with regard to freedom of speech. So I talked about the Sedition Act of 1797. So that was where we kind of got off to the wrong foot as far as freedom of expression was concerned, speaking about our federal government. So we also had the Espionage Act of 1917 placed into effect by President Woodrow Wilson, and it says since then it's been used to criminalize the disclosure of national defense and classified information. So this slide, and it's one of the ones that you can find at the bottom in the notes section of the PowerPoint, just speaks to the Espionage Act and what it entails and how they went about using it. So I'm going to pause to get back to the place that we were in the PowerPoint, but no, there are some articles regarding the Espionage Act if you would like to reference those. All right, so the next case that I want to actually have you watch a short clip regarding is Schenck versus the United States, issued in 1919, 2 years after the Espionage Act was passed. And again, this is wartime, so you have to take that into consideration when you're looking at the court's decision here. So let's watch that, and then we'll answer some questions regarding Schenck versus the United States. But you definitely need to remember two cases. One is regarding freedom of speech, and one is Schenck versus the United States with a clear and present danger test, and the other being Brandenburg versus Ohio, which didn't come along until about 50 more years in 1969 with Brandenburg versus Ohio and the imminent lawless action test. So you've already heard that term before in this PowerPoint. So that is the actual standard today. Okay, so hopefully you gained an understanding for the time period in which the Schenck decision was issued. We were involved with World War I. We needed men to join the Army. That wasn't happening. The draft was issued, and then Mr. Schenck decided he wanted to protest that in the form of handing out pamphlets equating the draft to essentially slavery. So the court didn't take to that too kindly, and they said that that presented a clear and present danger to our country. And so as a result, that would not be protected free speech. That changes here eventually, as you will see. So give me one moment to get to the case where you see a change in the test from the clear and present danger test, although sometimes those words are still used. Okay, so the next case where there's a significant change in freedom of speech comes during the 60s, the latter 60s, 1969 to be exact, with Brandenburg versus Ohio. And you'll notice that he has this pointy white hat indicating that he is a member of the Ku Klux Klan in Ohio. So he is challenging an Ohio criminal syndicalism statute, and the reason for that is that he was cited with the violation of that statute while holding a KKK meeting. And the court speaks to that in this decision, so let's see how that plays out and what their logic was in coming to the decision that they reached. Okay, so with Brandenburg, they completely reversed course. It was the 60s, you know, you had people wearing weird clothes, doing weird things. So why not have the Supreme Court issue a decision that directly contradicts their other one? We were involved in a war during 1969, believe it or not. That was the Vietnam War. I think my dad was over there from 67 to 69. So he was there for 2 tours, and he would talk about it as, you know, as we were growing up. And so we got a lot of insight as to kind of the horrible situations that some of those soldiers were put in. Regardless, they formulated the imminent lawless action test. And Brandenburg's action in allowing the media to come to his KKK meeting was okay for the court, because it wasn't, they weren't calling for the overthrow of, you know, a government, etc. There was not going to be an imminent lawless action that was created as a result of that meeting. So found the court. Today, you just never know. So, you know, things can go south very quickly. So I just urge you to err on the side of caution when you're meeting with people who don't always have the best intentions. Now, this next group is Westboro Baptist Church, and it involves funeral protesting. So the Supreme Court came out and said, yeah, funeral protests are okay. The Court of Appeals had ruled in the favor of the soldier's father, because the soldier's father had a funeral in which these protesters showed up, so he was going to get millions and millions of dollars. The Supreme Court disagreed. They said that, you know, the hate speech was protected, but they did mention that as far as the funeral was concerned, these individuals were far enough from the funeral procession not to have bothered the father. So the father shouldn't have seen them and really shouldn't have been upset with, their protest. So had they been closer and more violent or something to that effect, perhaps the court would have found differently. So, hate speech, protected, hate crimes, not so much. You want to also look at symbolic speech. Symbolic speech, wearing of armbands in support of, a cause. That was an issue early on. And then you have the burning of the flag, which was addressed, or the U.S. flag, which was addressed in Texas versus Johnson in 1989, which the court stated was symbolic speech. So he was exercising his right to speech by burning the flag. And people still will actually engage in that activity to make a point. In fact, they did it during these protests. I recently saw a flag being burned, which meant they're dissatisfied. These individuals are dissatisfied with government's current action or inaction as it relates to Black lives. So we're going to pause there and we're going to move to the next slide. It just mentions that restrictions are allowed based on national security or disruptions to daily lives. And then it also notes that, the government can place time, place, and manner restrictions, which is repetitive of something that we've already covered. So hopefully you've got that down. Learning Objective 4.4, explain the principles underlying the freedom of press. So again, with the Sedition Act of 1797, you had the press being faulted for what they were printing about the parties. And the newspapers were in fact owned by the parties. So that's where it became problematic. Next, we want to look at prior restraint. Let me move this. I don't know if you can see it or not. So with regard to prior restraint, that's the government prohibition of speech or publication before it occurs. Now, if that's going to happen, big star becomes important. There is an extreme burden of proof on the government. The government is going to have to show that national security will be damaged as a result of those publications. So that was going to be the argument. I believe in the Post, Meryl Streep represents the head of the Washington Post. And she makes the decision to take an article that the New York Times was not being allowed to publish and published it on her own regarding the Pentagon Papers. So the Vietnam War, unfortunately, went on and on and on and on. And casualty after casualty and body bag after body bag returned home. And people became fed up with it. And so these reporters got wind of it, so they decided to publish this piece advising that the United States was aware during several presidential administrations that this was an unwinnable war and that we were just wasting our men's lives and our taxpayer money by being over there. And recently, there have been papers that have been released regarding Afghanistan. So the same is true there as far as, the release of this information. Should it be public knowledge or does it endanger national security? Both papers, the Pentagon Papers and the Afghanistan Papers, were allowed to be published because the burden is on the government to show that it would be harmful in the release of those, and it's too high of a burden. They could not make that showing. So if you get a chance, at least watch the trailer to see if you would be interested in watching the Post. It's really good. Okay, section 4.5. This should be fairly simple. you wanted to be able to distinguish between the establishment and the free exercise clause, or the free exercise of religion clause. So it's fairly easy to do. In fact, let me just go to the clause itself. If you look at the way that it's written in the First Amendment, it says, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. So that's just the two quickly summed up. You have two various religious clauses within the First Amendment. So within this establishment clause, it says that government can't favor one religion over another or support religion over no religion. And it addresses the doctrines of the wall of separation of church and state, as well as accommodation of those who want to practice certain religions. And then the free exercise clause, government is prohibited from interfering with the practice of religion. So government interference is allowed when the exercise of religious beliefs conflicts with an otherwise valid law. So there are some good examples of this, but it's going to be sufficient that you know the differences between these two clauses, which is pretty evident. The government can't make or establish a religion or favor one religion over no religion. And then with the free exercise clause, you can worship how you like without the government having any say-so in the matter. Now, we want to look at Lemon versus Kurtzman, and this involved funding. So certain funds were being given to schools, some non-secular schools applied for the funds, and they wanted to determine whether or not that created a problem. And what they found is that there was a three-pronged test that they needed to apply, and they called this the Lemon test. After this character, Lemon, took this case to the Supreme Court. So the question for the Supreme Court was, does direct state funding of religious school teachers' salaries and institutional materials with the requirement that it only be used for secular courses violate the Establishment Clause? And they held that yes, that it did. Any subsidies to religious schools are unconstitutional because they can result in excessive government entanglement. And then these are the three prongs of the Lemon test that the government spelled out. A government action is unconstitutional under the Establishment Clause unless it has a secular purpose, and arguably, the subsidization of these funds had a secular purpose. Does it have the primary effect that neither advances nor inhibits religion? So I believe it passed that prong as well. The only problem that it failed on was that third prong. It fostered excessive government entanglement with religion because they spoke of these non-secular schools using these funds potentially after school, etc., for religious purposes, and that would require potentially a great deal of monitoring, and that would result in excessive government entanglement, which they did not want.